Now, what happens is once we get an objection filed in the Chicago Board, we generate what's called a call. And basically, this is a notice of the hearing. And we need to have a meeting of the Electoral Board within 3 to 5 days after that call is received by the chairman. So we issue the call, and basically it's addressed to the candidate, to the objector, or objectors if there's more than one, and to the members of the board. By statute, we're required to serve that call on the parties both by certified or registered mail and by sheriff's service. So if you're going to be a candidate or an objector, you can expect a visit from your friendly Cook County Sheriff's deputy. And he will serve you with certain papers, including the call. If you are the candidate, you will get a copy of the objection papers that were filed with us. And the call will tell you that we're going to be meeting as an electoral board, and you must appear. Now, we anticipate that the first meeting of the Chicago Board of Election Commissioners as an electoral board will be on December 6th. That could change, but right now we anticipate December 6th. And what happens at that meeting is the board, we have a 3-member board, they convene, and they adopt rules of procedure. That's the first order of business. They will adopt rules of procedure. Again, you should have copies of the rules that were adopted by the board when it last met in May of this year. And then they will call the cases. They will assign the cases to hearing officers. In Chicago, we are unique in several respects, but one of them is that we use hearing officers who are all licensed attorneys in Illinois who are familiar with election law. And these hearing officers are vested with the power to conduct all of the hearings, to receive evidence, to hear the argument, to make a recommendation to the board. That recommendation or that decision is, again, merely a recommendation. It's not binding on the board. The board can accept it or reject it or modify it. But the hearing officer will conduct a hearing, and each party must appear at that hearing. It's going to be the same day as the day the Electoral Board meets, which, again, we anticipate will be December 6th. The burden of proof in all of these cases is on the objector. If you remember the language quoted in Section 10-8 of the Election Code, saying nomination papers being in apparent conformity with the requirements of the code are deemed valid unless objected to. And they are deemed valid until an objector proves otherwise. So the objector has to come forward with what they call preponderance of the evidence. In other words, more likely than not, it's true. Preponderance of the evidence. It's not beyond a reasonable doubt. They simply have to come forward with enough evidence to show or prove that a point is more likely true than not. The rules of procedure, Section 10-10 of the code does require an electoral board to adopt rules. Doesn't require that they be in writing. Doesn't require that they contain certain minimal information. It just empowers the board to adopt the rules of procedure and evidence. Now, we have traditionally adopted written rules, and from the documents you have, you can see that these rules are pretty extensive. This is really probably the rules of procedure are probably the most important document you will get, and you will get a copy of these in draft form when you receive a copy of the call. So study them, know them. because this will be your blueprint for going forward. You must understand these rules. And if you don't understand the rules, please do not hesitate to ask the hearing officer, and he or she will explain the rules. But a misunderstanding of the rules can be fatal. And because you misunderstood the rules or failed to comply with the rule, could result in some serious consequences for your candidacy if you're a candidate, or your objection if you're an objector. So please, please read the rules carefully. Understand them. If you don't understand them, ask questions. A lot of what we're talking about today are taken right from the rules. We're kind of summarizing here in very quick fashion what the rules say in very, very complete detail. And I should say also about the rules of procedure and the rules of evidence, especially on the rules of evidence, we generally follow the rules of evidence that are followed in the Circuit Court of Cook County, or the circuit courts anywhere in the state of Illinois, for that matter, except where the rules provide otherwise. But we are not bound in all particulars by those rules. And probably the best example has to do with hearsay evidence. If you're on trial in the Circuit Court of Cook County, there are very strict rules about what kinds of evidence you can admit or submit for the court to admit. One of the rules is rules of hearsay. We do not follow a technical version or interpretation of the rules of hearsay. We allow, for example, affidavits from third parties, which are not ordinarily accepted in a circuit court trial. So we do relax them a little bit, and we're not bound by the rules of evidence or rules of procedure in all particulars, but we kind of look to those rules for guidance as we proceed through this process. I talked a little bit about hearing officers, and they're basically given all the same duties and powers that the Electoral Board has. They can hear all of the evidence. If you have witnesses, the witnesses will appear before the hearing officer. They will hear the testimony. They will accept whatever evidence you have. They will administer oaths. They will check signatures. They're empowered to issue or make their own determination, for example, as to whether or not a signature is genuine, if that is the issue in dispute. They have all the powers and duties the Electoral Board has, except to make a final decision. They make a recommendation for a decision, which will go to the board and, as I said, may be accepted or may not be accepted or may be modified. Substitutions. If you have reason to believe that a hearing officer that you've been assigned to is not going to be fair, you can ask for a substitution. And we will do that at the initial hearing. But you have to do that before you start getting into any substantive issues during the hearing. You have to do it prior to the commencement of the hearing. And if you make that request for a substitution, we will make that substitution. You will get a new hearing officer. If you don't make the request before the commencement of the hearing, then you can only get a substitution of a hearing officer upon good cause shown. So you're going to have to demonstrate and persuade the board that the hearing officer is not being impartial or is not otherwise qualified to hear your case. And that's a substantial burden. More often than not, those kinds of requests are not going to be granted. Sometimes they are, if there's good reason for it. So if you're thinking about, you don't like John Doe as a hearing officer, make the request up front. Okay, any questions so far?
How many hearing officers are there?
Okay, I'm gonna repeat the question. I forgot to repeat it the first time. So, the question is, how many hearing officers are there? For this season, there will be 26 hearing officers. 26. We're anticipating a large number of objections. So I trust we'll be prepared. Any other questions? Yes, sir?
Yes. Do you know of the hearing officer's decision prior to him sending it to the board?
The question was, do I know the recommendation of the hearing officer, or do you know?
The candidate. Does he learn of the hearing officer's decision?
There can be done one of two ways. It may be that at a hearing, at the conclusion of the hearing, the conclusion of the trial aspects of it, the hearing officer may tell you on the record that based on the evidence, based on the law, here is what I am going to recommend. And he will tell you right on the record. Now, he's also required to write that up and submit it in written form to the board. But you will know what that decision is. The other way that hearing officers sometimes handle it is, I want to take some time and I want to review the evidence that's being submitted, or I want to review your arguments or briefs and take some time to think about this. And when I am ready to make a decision, I will let you know either one of two ways. I will come back, I will have another hearing, or I will just issue a written decision and you will get a copy of that decision.
It's prior to the board.
Correct. Okay. Any other questions? Yes, sir, in the back.
Ultimately, will there be any date that a candidate knows for sure that they're on the ballot?
The question is, ultimately, will there be any date where a candidate knows he's going to be on the ballot? No. I mean, there are no, we have certain deadlines for doing certain things, but there's no deadline set in the statute for us rendering a decision. Again, we try to do these things as quickly as we can. And as I said earlier, in 2007, I think we rendered all our decisions within 30 days. It may go longer than that. Sometimes things get a little bit more complex and we go beyond the 30 days. You know, we're going to take as much time as we need to make a decision that we believe is sound and is supported by the law. So there's no particular deadline. And then keep in mind, again, even notwithstanding our decision, the other side, the other party, an aggrieved party, can take it up to the Circuit Court of Cook County. So even if we issue a decision saying the candidate is on the ballot, doesn't necessarily mean he's going to be on the ballot, because the Circuit Court may disagree with us, or the Appellate Court, et cetera. Yes, sir. I'll try to repeat the question, but I'm not sure I quite understand it. Your question, I believe, is if you're running against a candidate and that candidate dies, for example, before the election, you mentioned, I think, December 15th, what happens? Well, December 15th, we're not likely to have a ballot printed, so there's no concern there. After the ballot is printed and someone dies, then that becomes much more complicated, because we may not have time to remove the name of that candidate from the ballot.
Okay.
And you know, that presents a difficulty that unfortunately occurs from time to time, and someone dies, you know, someone dies the day before the election. They're certainly not going to be able to change the ballot. You know, I had mentioned earlier that in 2007 we had a decision from the Illinois Supreme Court the Friday before the election. And that decision was telling us that there were two candidates who were not eligible to be candidates. Their names were on the ballot, but they weren't eligible. Well, it was impossible to take their names off the ballot at that point in time. And so we got some direction from the Illinois Supreme Court to disregard all the votes cast for that candidate. So it does get complicated.